For your Lord. One matter was listed today, my Lord, for framing of charges. I give the for 18 years, my Lord, I am suffering without job, my Lord. Today it was listed, it was not in. I'll give the number, my Lord. The earliest date may be fixed. All that I am asked for. Earliest date is given. Framing of charges. Today was the date given. Today is not. Are they correct? Any date, Lordship's convenience.
That will be
any date, your Lordship.
It will be posted.
Please, earliest convenience.
The criminal contempt.
It is, my Lord, for framing of charges, my Lord. Yes, not civil contempt.
KPSC.
Yes, my Lord. Please, please, please.
Yes.
Number I appear to the appellant.
23 or 24.
Lord, I am the state load dispatch center, Lord. I am a state body which controls the movement of power, Lord, within the state, from a generator to the generating station and onwards to the distribution company. Lord, the state government issued a notification under Section 11 of the Electricity Act. The provisions of Section 11, Lord, provide that in the case of an extraordinary situation, the state can make an order that power which is generated within the state should be dealt with in a particular manner. The section itself contemplates that the state is not getting it free. It is only directing the generators that you have to work to full capacity and you must supply this power to the state grid. State power purchase company is there, Lord, which will purchase the power and distribute it within the state. The section also, my Lord, provides that the tariff at which it is to be given to the state is also fixed in the government order. And there is a provision under Section 11, subsection 2, my Lord, by which the Electricity Regulatory Commission, which is an independent regulator, that will have to fix the ultimate tariff that is to be paid by the state to the generator. So really speaking, the generator is not affected in any manner. Whatever it generates, it will hand over to the state. State will distribute it within the territory.
In normal circumstances, the generation of power by these licensee companies would go to the grid of the state.
They have, my Lord, a choice. If they enter into a power purchase agreement with the state bodies,
so the electricity will go where?
Yes, they can supply to state bodies.
Even in normal circumstances.
In normal circumstances also they are permitted to do that.
So now what is done?
Now, my Lord, what has happened is because of this extreme power situation that we have, the state has made an order under Section 11 saying those generators who are situated within the territory of Karnataka, they cannot sell the power to anybody else. They must sell it only to state, and state will pay them also. State will pay them the rate that is fixed. Then the independent regulator will look into their financials and thereafter make an order, you pay more or less. Now, my Lord, this order was challenged.
That order is set aside now.
Yes, the order, my Lord, has been set aside.
And there was no interim order of Section 11 before the single judge, my Lord. So if there was no stay of that, it continued till now. Now, by virtue of the impugned order, it has been set aside, my Lord. The matter request to be heard, my Lord, and the division went directly in our favor, my Lord.
The problem that we are facing now, my Lord.
State has not filed any appeal. They also filed appeal. That second appeal is
Second
yours.
appeal. In fact, the Section 11 directly on the point, there's a judgment of the division bench, my Lord. The learned single judge follows the Supreme Court judgment, which does not deal with Section 11. This is directly on the point of Section 11.
That is global energy.
GMR.
I am on caveat, my Lord.
What is the basis of the judgment of learned single judge?
Well, learned single judge says
Breach of the license condition.
No, my Lord. There's the learned judge.
In fact, this is directly on the point, my Lord.
Extraordinary circumstance. State which will be the body.
The division bench of this honorable court, my Lord, in GMR went into similar exercise of power under Section 11 came to the conclusion that this is an extraordinary situation, the state can do it. The learned judge, my lord, refers to a later decision.
This judgment was cited before the.
Yes, my lord, cited, my lord. What happened was this judgment was taken up in appeal to the Honorable Supreme Court. Their lordships, my lord, did not interfere with this, said we are leaving the question of law open because that order was passed quite a number of years ago.
Against this order.
Yes.
What is meant by kept open?
Kept open
When
means,
there
my
is
lord,
already a
in a
judgment.
future, their lordships did not set aside this order. They said if this issue arises in another matter before the Supreme Court, we cited authority, my lord, 2 division bench judgments of the
That's all
Gujarat.
right. What we want to know
Yes.
is where a well-considered judgment is put in challenge at the hands of the apex court of the country, and the apex court says the question is kept open. Does it mean the presidential value of the judgment is robbed away?
Answer is respectfully no, my lord. In fact, we cited authority for that. We said this judgment is still valid. In the facts of that case, their lordship said we are not deciding it, but this law is still valid. We cited that, my lord, before the learned judge. The other side, my lord, relied upon a later decision of the Supreme Court.
Which does not deal with section
It does
11.
not deal with section 11 at all. It deals with another situation as to whether the tariff for certain category of generators should be decided by the Central Electricity Commission or the State Commission. And who is the appropriate authority in this?
Power to fix the tariff,
Exactly, my lord.
not whether the power can transcend to other states, etc.
That's
the
not an
subject
issue
matter.
there.
It was not in the issue.
Section 11 speaks of that conspect.
Exactly.
Yes, absolutely. When there was a direct judgment on under section 11 of the.
How other high courts in the other states have interpreted this provision? Any
No
judgment?
My lord, there are no judgments, but what we cited before the Supreme Court, my lord, in this is the number of states, my lord, exercise these powers. And we didn't find any challenge to this provision in other states.
In fact, Karnataka had issued this same section 4 times earlier, no challenge to it. For the first time, I mean, the one challenge was there, upheld. Earlier 2 challenges, they had not challenged it.
2 high courts, my lord, followed this judgment in GMR case. After GMR's decision, my lord, 2 other high courts, they had challenged it. And those high courts, my lord, have followed GMR and dismissed the challenge. Now, our difficulty is this.
May I respond?
Honorable Chief Justice had occasion to deal with somewhat similar situation sitting as a learned single judge in Gujarat. We cited it also before, my lord. Your lordships have said, what the meaning of leaving the question open?
What is this CH-1? What is it? Full.
Gnanam.
My lord, in the state, there are different areas, my lord. For each
Yes.
area, HCOM is Hubli Electric Supply Company. Mangalore, my lord, they call it MESCOM.
Name of.
It's just an acronym.
Electric company. Just
If your lordships, my lord, could go to page 1, para 24 in this judgment, my lord. The division bench ruled about the correct position thus.
This is different. This is education.
It's education, but your lordships are considering what is the meaning of leaving the question open. If Honorable Supreme Court says question is open, does it mean that it is not to be followed? Second line in the court, my lord. When a question of law is kept open by the Supreme Court, not entertaining an SLP against the judgment of the High Court, in fact, what is done is neither to confirm nor to dilute the ratio of the judgment under challenge. That, however, does not mean that the High Court in a future case is allowed to take a fresh view, ignoring the law of precedents. It only means that the Supreme Court refused to bind itself.
You are reading 24.
Para 24, my lord, the para begins like this: the division bench ruled.
Correct. The division bench ruled about correct
Yes,
position.
there is a court, my lord.
Where exactly you are taking us to?
My lord, if your lordships in that court, my lord, we are in full agreement in that para.
When a question of law is kept.
Third
open.
line,
When a question of law is kept open.
please.
Second line.
When a question of law is kept open by the Supreme Court, not entertaining a specially petition against the judgment of the High Court, in fact, what is done is neither to confirm nor to dilute the ratio of the judgment under challenge. That, however, does not mean that the High Court in a future case is allowed to take a fresh view, ignoring the law of precedents. It only means that the Supreme Court refused to bind itself or put its seal on the ratio propounded by the High Court in the judgment and the challenge. Therefore, when an identical question comes up before the same High Court and is presented for consideration before a bench of coordinate strength by virtue of the principles of law of precedents, the bench should be bound by the ratio of the earlier judgment of the High Court, unless persuaded to refer it to a larger bench. This is precisely what has been recorded by the division bench in the said case, and this is why the bench was of the opinion that it had either to follow the ratio in the case of General Motors or make a reference to a larger bench. Now, we cited this also a lot, but the learned judge seems to think that energy watchdog, there is some observation in that.
It appears this judgment is made keeping in view Kusum got.
Please,
What happens is, where one High Court interprets the provisions of a central piece of legislation, a piece of central legislation, then that judgment would not be just of a persuasive value, and it will be binding as if all other High Courts are coordinate benches. of
unless
High
any
Court.
other High Court has taken a different view.
That question does not arise because
Yeah.
where High Court has already taken that view, that will bind this court.
Please.
Therefore, that question will not arise. But this question perhaps arises because of central legislation, and
Please.
Electricity Act is a central legislation.
Central legislation.
At the most, court wanted to, we do not know.
And
In
whether
fact,
the learned single judge, the learned single judge,
No, the point is kept open, therefore I am not bound by it. That will be chaos. Yes. Perhaps this judgment may not carry the presidential value before other high courts at the most,
please, please.
because of Kusum got.
At least single judge, at least your lordship division bench may refer to the larger.
Otherwise
bench
it
or
will
the
be-
Single judge,
Single judge was totally bound
Yeah,
by.
yeah, I
bound
know.
by-
How learned single judge has treated this?
The learned judge, my lord, has said, looking at the later judgment in Energy Watchdog, the Energy Watchdog judgment, my lord, as I
Does
submitted,
not relate to 11.
does not relate to 11 at all. But in passing, my lord, their lordships refer to the definition of the term appropriate government. So that's the distinction, my lord, which the learned
And
judge-
learned judge said it is central government.
yes. And that binds is the view that the learned judge.
The central government, no purpose of issuing
Will be
section-
served at all.
section-
Very purpose is the special circumstance, extraordinary circumstances in the state.
For a limited period.
It cannot be for the whole of the country that way.
May I?
Not,
Sorry.
Are you on
Central-
caveat?
Yes, I'm on caveat. In fact, it was served last night, Lord, and still I'm ready. I'll make submissions, Lord, when permitted. When permitted.
We can-
but the urgency is only this.
where is the impugned order letter?
No, the impugned order, my lord,
20th June, page
Yeah.
260.
starts at page, my lord, the 31
Page? No, no.
in my appeal, my lord, in 526.
No, no,
That
impugned
noted-
order of the
that noted-
section 11 order.
Oh, I'm sorry. Section 11 order 216. The operative portions are 219.
Yes, 219.
The circumstances explained in the preamble and in the exercise of power under section 11, state government in public interest hereby issues the following directions with immediate effect until further orders. All generators in the state of Karnataka shall operate and maintain their generating stations to maximum exportable capacity and supply all the electricity generated to the state grid subject to following conditions. Condition 1, my lord, is an interim payment, 4.86. Then capacity, how they should give. And the allocation to various distribution companies is there.
220, serial 3. no. Deputy Secretary.
And to fix the tariff,
Let us ask.
May I?
It's for electricity matters.
Please, the respondent before your lordships, the first respondent on caveat is a trading company, my lord. I have taken license from CERC, Central Electricity Regulatory Commission. Now, my lord, at the outset, if my lords were to see the section 11 order, which my lords directed to produce, the order is, my lord, specific to the generators. The section 11 order says, page 219, my lord, the first clause says, am I reading with your lordships?
Yes,
All the generators in the state of Karnataka shall operate and maintain their generating stations to the maximum exportable capacity and supply all electricity generated to the state grid. Now, my lords may see what is my status. I am, my lord, a interstate transmission licensee who has obtained a license from Central Electricity Regulatory Commission. And therefore, my lord, a state government cannot compel me to say, even if this order remains, saying that, my lord, all generators shall supply. I am a trader. I am buying power from the generator, supplying to interstate. Now, my lord, what has happened? The whole grid is integrated. It is called, my lord, the news grid, north, east, west, south. The entire grid is one. The national grid, my lord, whatever power is supplied or whatever power is to be taken, the impact is pan-India. There is no state grid, there is no state, my lord, or district grid or taluka grid. The grid is one. So therefore, my lord, what central government did by enacting the Act of 2003 with a benevolent intention of liberalizing this power flow across India, said traders like me, we will carry power to other parts of the state. Suppose, my lord, sorry.
To state grid.
Yes.
What is meant by that?
Grid means, my lord, there is a grid system within the
Within
grid
the
is
state
defined.
also.
Yes,
That
within the
means it
state
will not go to news grid at all.
news. It goes to the state grid. It was enacted when enacted, my lord. There was that distinction: state grid, national grid, etc. Now, my lord, after 2011, the whole grid is, my lord, one. There is one grid. Earlier, my lord, there was new grid, NEW.
Under which news grid
Yes,
is
I had
under
produced
section?
that before the court, my lord, but that is not part of these records. I'm just on caveat. Yesterday, my lord, I received. I can produce the document to show that national grid is one. And secondly, my lord,
May I just make one submission so far as my learned friend is concerned, my lord?
State grid even now obtains independent of national news
No.
grid.
No, my lord, grid is for geographical reasons. They say north, south, east, west. There is one grid for the whole country.
yes,
State grid is one of them.
State grid is, my lord, the entire electricity lines which run inside the state is called the state grid. So, my lord,
They are
from here,
asking
yeah,
this news grid, which he said, we are using his terminology now. We do not know what it is. Whether the expression state grid employed in page 219,
yeah.
does that state, that entity maintains its identity independent of
no,
the
No.
news grid?
no.
There's
No, no.
only one grid, my lord.
Yes,
The
there is one
grid is
grid.
an expression that they use for electricity lines which are conveyed.
What he wants to say is perhaps this separate identity question would not arise. And therefore, the state alone tapping the power
That parochially.
independently as if it is its own quota will not arise. Is
Yes,
sufficient.
yes.
But what I am submitting, my lord, is the person who is before your lordship, my lord, is a trader. This order under section 11 is an order to the generator. The generator,
Both the words are defined.
yes,
Trader is
Yes,
defined.
yes. Therefore,
trader as a, yes.
I'm completing
Yes.
my argument.
This,
my lord,
this
to say.
direction is to say that if you are a generator who is located within the state, then you must supply to the consumers in the state. That's all. Now he is a trader, my lord. He has taken a trading license. What is called as a power exchange. Now, my lord, a trader can go and buy like who would buy in the stock exchange, no stocks and shares. You can buy on the power exchange,
Sell also.
or
Yes.
you can go to a generator and say that I'm a trader. You please supply me X number of units of power.
Is he generator or not?
He is not a
I'm not
generator.
generator.
Then
That's
how
what I'm
you are?
submitting.
That is the precise reason.
There
my
is a
lord.
force majeure
I'll
clause
answer that.
in his
He
contract.
cannot bind me. I'm sorry, my lord. He cannot bind me through this order. I had a tie-up with a generator, my lord, EDCL, a hydro company. I, my lord, applied on behalf of that. May I persuade, my lord, before that? Trading is a defined term under 271 of the Act to mean I purchase electricity and resale thereof. So I was constrained. He cannot, my lord, pass a Section 11 order and constrain me. I applied for an open access saying that I want to sell power outside. I am a central government licensee. I have taken license. Under the Act, I have permission to sell. He restrained, SLDC restrained me.
No, your license
Yes,
creates personal interest in you. That's how it is. A license creates personal interest.
correct. The,
Number two,
yes,
going further. Section 11 speaks of public interest, interest
Correct.
at large.
correct. Exactly.
Assuming
Yes,
that there is conflict,
yes.
Section 11 will
Yes.
override
Yes.
whatever
May I-
little
may I-
rights
may
we
I
have.
answer that? Yes, ma'am. In fact, it overrides. That is my case as well. When, my lord, the trading, like the SLDC cannot restrain me. There are, my lord, two regimes incorporated. In fact, my lord, the central government also has issued Section 11 to say, whoever appropriate government, I am appropriate government for so and so projects. In your case, you obey my orders. For me, the appropriate government is the central government, not the state government at all. That is the whole case, my lord.
Slowly.
Yes,
Whether the concept of appropriate government,
yes.
is it generator specific or licensee specific?
It is generator specific,
Then
licensee
where,
specific. Am I reading? I'll read. The appropriate government is
Because
defined to
section
be-
uses the word generator.
Yes, in respect of a generating company, I'm reading law 2(5) of the Electricity Act. The central government in respect of a generating company, wholly or partly owned by it, then it becomes not central government. In relation to any interstate generation, transmission, trading or supply of electricity, and with respect to any mines, etc., etc. So in my case, I am, my lord, a interstate trading licensee. And if, my lord, each state starts putting embargoes on me, interstate entities like me.
Only exceptional circumstance.
No, my lord, there is no exceptional situation.
Section 11
Yes,
is couched in such a language.
correct. There was no,
Ordinary
no,
circumstance.
Section 11 empowers an appropriate government to issue orders, and it is not a state government power alone. Central government has already issued Section 11. It is, my lord, that order that can bind me. May I persuade your lordships to see Section 11, my lord? Appropriate government.
Because the state government will be knowing
Yes,
the extent of power requirement in the state,
yes,
the extent of power supply in the generation in the state,
correct.
supply, then it takes a considered decision in
Exactly,
its
my lord,
executive
exactly.
wisdom.
But now,
Under
my
Section
lord, then the entire grid is one. If your lordships may, before my lord see Section 11, kindly see, my lord, the definition of grid itself. Grid is defined under the,
Where is that judgment of which watchdog?
I am, lord,
Energy watchdog.
Yes, lordships may allow me complete one aspect, my lord. Lordships asked me on the
No, we only
merger,
want-
my specific contentions are recorded, and why, my lord, GMR is deviated from.
I do not have idea.
Energy watch,
Section 11 specific.
Allah, that is, my lord. No. Who is an appropriate government is the issue there. Who is the appropriate commission is the issue.
What is the difference between the generating company and license?
Lord, there are
Generating company is not supposed to take license.
Yes, they are not supposed to take license, my lord.
The act requires,
Yes, they are free under the 1948 Act, my lord. There was a specific contention that the generator should take license. Now it is delicensed.
Which were the provisions that were scanned by the apex court in this
in this judgment, Lord,
energy watchdog?
para 2,
It did not travel to 11 at all.
No reference to Section 11 in the whole judgment.
Is it true, Mr. Prabhu? This energy dog
Yes.
does not
No, that's, my
say
lord.
anything. No,
Yes,
asking.
yes. I say, my lord, section, it doesn't deal with Section 11.
Done.
Yes,
Number
But
one.
what it deals, yes, sorry,
Section 11, it did not deal with.
yes,
The jugular vein of the case is notification issued under section 11.
yes.
Is it true?
No, my lord, the jugular vein of the case is,
Who is the
which
appropriate-
government can issue that direction?
That also will fall under 11 only.
Yes,
Appropriate government, to
May
my
I-
limited exposure to this act,
yes,
is employed in several provisions.
yes, yes, my lord,
So it takes color
yes, my lord,
depending upon the text
yes, my lord,
of the section.
yes, my lord. If I,
Section,
yes, sorry,
please, please,
sorry,
please.
sorry.
Section 11 recognizes the federal principle
Yes,
and gives autonomy to the state.
no, appropriate government, my lord.
Appropriate, that is the reason.
Yes,
Otherwise, it would have said central government,
yes,
federal
yes,
government.
yes, yes,
It's not
ma'am.
like that.
yes, my lord.
It is appropriate government.
Yes,
The electricity consumption and
Yes.
generation, the gap between demand and supply, the economics principle.
yes,
That will be adjudged by the state government.
yes. May I, my lord?
Therefore, section 11 is on the statute.
May I persuade your lordships to see what, whether at all, now if that is the issue, my lord, that whether at all there was a power deficit, we produced data from
There
their
is
own,
one, all right. Anyway, there is one judgment of the coordinate bench of this court
that, my lord, yes, that, my lord.
that dealt with section 11
They
in so many
withdrew the
words.
case. Now, my lord, I have dealt with the honorable judgment also deals with it, and I have specifically, my lord, my specific contentions have been recorded. And my lord, on that very issue, if your lordships may permit me to read that particular point, my lord, on how GMR was not followed, may I persuade your lordships to see page, Lord, 80. Sorry, 87, ink page 87, 15.7. That very issue is dealt with, my lord. Why GMR is not considered? Lordships may permit me, my lord, for a minute.
Also, it requires consideration.
Yes, your lordships may see so and so relying on the decision. I am reading 87, my lord. Permit me 2 minutes, my lord. I'll come. So and so relying on the decision of Kunyan Ahmed versus State of Kerala asserts that proposition laid down by division bench of the court of this court in GMR is jeopardized by the Honorable Supreme Court, assuming its appellate jurisdiction to consider and merits this decision, and with a later disposal of the appeals, recording the submissions that the state government's order dated so and so has spent itself out and observing that interpretation of provisions of section 25A2 of the Electricity Act being kept open for consideration, Shri so-and-so relies upon the following exposition in Kunyan Ahmed to contend that this outcome would only mean that decision of GMR is merged with the Supreme Court and proposition exposed in this decision loses its precedential value. That is, my lord, is accepted by the Honorable Supreme Court. And then, my lord, now already we are selling, now, my lord, central government has also imposed section 11. May I, my lord, the mitigating, the whole planning is done by the center. Tomorrow, my lord, every state start invoking section 11 and scuttle the section 11, scuttle the situation.
Then parliament would have said,
Yes.
no appropriate, it is central government.
No, my lord.
Yes.
Appropriate government, insofar as I am concerned, I am, my lord, a licensee of the central government,
You are
central
only a
commission.
licensee. Section 11 is generator specific.
Correct. I am not a generator, my lord.
You are not a generator.
I am not a generator. How
Therefore,
can
it applies
how
to
can
the
they stop, my lord? How can they stop me under that order is my,
Who are you?
I am, my lord, an interstate trader. I purchase electricity and sell.
Section 11, the impute notification does not apply.
Correct. That's what I am saying. Let that be.
Nobody prevents
I
him
didn't
from
interfere,
trading.
my lord.
Nobody
No, no.
prevents him from trading. He can go to the
No,
exchange.
no.
buy-
Can I say, my lord? 3 generators, they have filed appeal. They didn't bring it up, and my appeal is before your lordship.
Whichever.
No, no.
May
They
I
are free
make
to
one
sell.
submission, Millards? Millards,
May I
I
pass on the
appear for
central
one of
government
the,
section 11 order, my lord, passed on 12th April. In fact, my lord, all gas-based plants, the central government says that you shall increase your.
How you are aggrieved by this,
Yes,
what is your
that-
locus to oppose
Yes,
the petition?
the locus was, my
In the
lord,
petition.
yes, I am tied up with a generator with whom I have a contract.
You proceed against him in law.
No, my lord, no.
There's a force
My
majeure clause
application
there.
for open
That
access is not
contract,
stopped.
there is a force majeure clause.
No,
Government
that is
force
also
majeure.
dealt with.
So if the
That
generator
is
tells
also
him,
dealt with.
I can't supply, then force majeure will kick in there.
Lord, I'm
11 will be force majeure.
Absolutely.
11, my lord.
GMR considered whether a trader can do it. GMR says writ petition is not maintained.
No.
Yes, just point to the paragraph. No problem. GMR says trader can't maintain a writ petition.
My lord.
Lords, with your lordship's kind leave, Lords, may I make one submission, Lords? Lords, I represented one of the generators, Lords, before the learned single judge. And, Lords, I had also filed a caveat, Lords, in case, Lords, a writ appeal was taken up. Lords, I'm not even sure, Lords, whether the appeals have been filed against me, but I have not been served a copy. It's a common judgment, Lords. Even my writ petition is disposed of by way of the impugned judgment before your lordships. I'm requesting, Lords, if I may be given a copy and also heard, Lords. I am a generator, Lords.
Argue.
Who are you?
He's another generator.
My lord, I'm sorry. The section 11 order, why, my lord, it makes the distinction and gives empowerment to an appropriate government and not to the central government or state government is for this reason. There is a clear-cut regime differentiated, my lord, who are all regulated by central commission, who are all regulated by the central government, and who are, my lord, the embedded entities within the state over which state government can, my lord,
That's
exercise
true.
power.
But there is already
Yes,
a view available
yes,
from a coordinate bench,
yes.
which is bigger than the learned single judge.
No, my lord, it's Supreme Court. Yes, my lord, I bow down.
One second.
Yes,
Methodically, we will go under
Yes.
the law of precedent.
please.
Rupert Cross on English law of precedent.
Yes,
Now, there was a division bench judgment before the learned single judge.
yes,
And the decision of the apex court was miles away from section 11, though it dealt with appropriate government,
yes,
which concept is employed in section 11 also.
yes, my lord.
Section where as between two decisions cited, this is what
Yes.
Rupert Cross says, apex court in Meenakshi Mill has accepted, where two decisions are cited before a court,
Yes,
the one which has more proximity in terms of facts
yes,
should be followed.
yes. Now,
This division bench said, and apex court did not upset it. Though it said in so many words that question is kept open.
it did, my lord, it did. My respectful submission is, it did.
We referred to
It did.
Constitution bench in Padma Sundar Rao's case.
Yes,
It,
this matter was carried to Supreme Court and Supreme Court kept the question open.
Yes.
no, the matter was withdrawn and that is what I have precisely addressed, my lord.
Anyway,
Energy was
It's a-
sought. Yes,
its presidential value is not robbed away unless set at naught or apex court says it is bereft of presidential value, it only enjoys
it-
res judicata as between
it
the parties. That's
impliedly
not the-
said so is, my lord, my respectful submission. 117, my lord, I have said so and this is, my lord, part of the judgment. May I, my lord, persuade your lordships to see Kunyan Ahmed case. To see, my lord, if GMR is to be taken as gospel truth and the presidential value of GMR is to be accepted, then, my lord, that was passed under an extraordinary situation. Now, I have also contended, shown the records that there was no extraordinary situation in this case as well. And that is also, my lord, equally important. And my lord may see,
Who should say whether there is
Minister-
extraordinary
state,
circumstance or
state,
should say?
and state has said
Prima
so.
facie.
State has said so in 345.
Correct.
I have produced the records from state itself, my lord, and National Grid also to show that there are no extraordinary situations. In fact, they have produced
Order,
that.
notification. The
Yes.
order,
Yes, my lord.
notification issued under section
Yes,
11
yes, my lord.
at the paragraph 18 perhaps,
Yes, my lord.
specifically says.
Yes,
there
my
is
lord.
Extraordinary.
Correct.
circumstance.
After that, my lord, what happened is the important consideration, my lord, that should, in fact, section 11 is a reality. When it was imposed, maybe, my lord, there was extraordinary situations. And thereafter, 345, page 345, my lord, very specifically says, there are no extraordinary situations. There is no deficit at all. And section 11, that is what, my lord, I am pressing to surveys, that central government understood that there is a national deficit, imposed section 11 as latest as 12th April. The section 11 is imposed and situation is mitigated. There is one grid. Each state cannot say, my lord, in my state there is deficit.
What was the stand of the central government before?
Central government said I am the appropriate government. That is what I'm grateful Lordships raised this
Not
issue.
that. About
Extraordinary situation.
extraordinary circumstances.
No, they said, my lord, I am the appropriate government. No question of the section 11
We
order.
are asking a question. You are taking us to another question.
Yes, my lord.
We are not asking who is the appropriate government now. That requires consideration. We are only asking
On the
whether
extraordinary,
central government denied the existence or obtainment of extraordinary circumstance.
they did not support the state, my lord.
No, we are asking you
Yes,
again.
my lord.
They did not support because they said that they themselves are the appropriate government.
Yes.
That's all.
No, even otherwise also, my lord.
And whether they denied that one, that there is any,
They filed
extra-
objections and, my lord, they,
have they said that?
in fact, my lord, central government may be notified. I don't have a copy, my lord. In my case, they did not file. My learned friend may have their copy. That may be, my lord, part of the records. Allah, central government's response is part of the records, my lord. Let them produce as part of the state.
Insofar as the petitioner is concerned, my lord.
Allah, let them answer that pointedly, my lord, what central government said. Central government supported us. And, my lord, may I persuade again, my lord, to,
Did it again? My question, our question remains unanswered.
it is part of their record, my lord. I'm so sorry. It was,
Anybody will be in a position to answer this question?
In this case, they didn't
Central
file.
government,
They did not file. What had happened
They
was,
did.
there was a main case of JSW. In that they filed.
Had they filed?
yes, JSW, they filed in JSW, which was connected and then withdrawn. And with JSW, they have entered into a contract, my lord.
We are asking you
Yes, my lord.
whether central government had filed its pleadings.
Yes, it did, my lord, in the connected matter.
In those pleadings.
Yes, my lord.
Has it denied the extraordinary circumstances pleaded
No.
in
No.
the notification?
Let them produce that response, my lord.
No.
No,
no,
let them be, my lord. No, but this oral saying, my lord, it will be oath against oath. The central government, my lord, said, I am the appropriate government. I had one contract.
Not on that.
No, no, my
We
lord.
are not on that. Whether it is state government or the central government,
Yes, my lord.
the sine qua non for invocation of section 11 is the obtainment of extraordinary circumstance.
Yes, my lord.
Therefore, we are asking whether there is any bone of the question of extraordinary circumstance was the bone of contention between the parties, not you,
Yes.
as between the
Yes, they were all
and
connected.
the federal unit.
Yes, my lord. They were all connected. And in that, central government said,
Show that.
the connected matters, my lord, the pleadings are not before your lordship.
According to you,
Yes, my lord.
which part of this energy work supports?
Yes, that, my lord, today the copy was served. We were not even aware the matter will be aware, lordship.
Judgment.
Yes. Copy of- I'm sorry, my lord, because it was not part of the cause. Great. The energy watchdog, my lord, I have to not be very,
Well, this energy, electricity,
Yes,
is
Lord.
it in a central list?
is
or
a concurrent list,
concurrently?
concurrent list. And therefore, my lord, the lordships may see, the discussion starts from page 15 onwards. And my lord, the particular paragraph is also extracted in the judgment itself, my lord.
It is only with respect to.
The
which is
appropriate government.
appropriate
Yes.
government.
May I, my lord, read para 22 of the judgment? Para, lordships may see 21. 21, para 21 of the energy watchdog judgment. My lord, I have a Supreme Court report with that downloaded copy, my lord. In that, my lord, the paragraph starts, in order to appreciate and deal with this submission. Para 21, my lord, 2-1
Page 27. my lord.
22.
in the internal page
In
27.
order to appreciate.
Yes, in order to appreciate and deal with this, in fact, my lord, I'll read the preceding paragraph as well. The appellants have argued before us that expression composite scheme mentioned in 79(1) must necessarily be a scheme in which there is uniformity of a tariff in the PPA, where the generation and sale of electricity is more than one state. It is not enough that generation and sale of electricity is more than one state be subject to matter of one or more PPAs, but so and so. That, my lord, in order to appreciate and deal with this submission, it is necessary to set out section 2.5. My lord, they quote the appropriate government. Then, my lord, go on to see section 25 and 30 to say,
They are supplying to outside state.
yes. So therefore, my lord, the scheme that emerges, my lord, this is crucial. The scheme that emerges from the section says, wherever there is interstate generation or supply of electricity, it is central government that is involved. And whenever there is interstate generation or supply of electricity, state government or the state commission is involved. This is the precise scheme of the act, including section 79 and 86. It will be seen that section 79(1) itself, so and so, speaks of interstate transmission and interstate operations. Now, my lord, what happens is, if my lords were to subject me, an interstate entity, stop me under that order, where will I go? I will not be able to take compensation from commission, nowhere I go.
Then that amounts to manhandling section 11.
Yes.
Why is a parliament used appropriate
Yeah,
government?
it is because, my lord, therefore, my lord, again and again, I am requesting, section 11 orders are passed routinely by the central government. If there is a deficit today, it is bridged by the central government. If they want to restrict an interstate entity like me, they will issue an order under section
Kindly
11.
come to para 24.
Yes, my lord.
Class item B,
Yes, my lord.
little below that.
Even otherwise, the expression of 7.
No,
I'm sorry, my
It
lord, I
begins
don't
with-
have the.
it begins with the state commission's jurisdiction
Yes.
is only where generation and supply takes place within the
Yes.
state.
Yes, my lord. Yes, my lord. I'm
On the
sorry.
other hand, the moment generation and sale takes place
Yes.
in more than one state,
Exactly, my lord.
the generation is in the state.
No, my lord.
Generation
Yes.
is within the state.
Correct. Generation is within the state. But I am an interstate trading licensee, and therefore, my lord, they cannot stop that open access from imposed.
Again, right. The two appellants, the two appellants in the respective, the appellants in the two respective again, write down, sorry. The appellants in two writ appeals are the State Load Dispatch Center and State of Karnataka respectively, who were original respondent number.
I was, respondent number, my lord, was 4. SLDC was 5, my lord.
My lord, I had filed.
Four
And the
respectively.
state was respondent
5
number
and 4.
2.
Lord, before the on a single judge who have addressed challenge to the judgment and order of law on a single judge dated 11th March 2024, passed in common in 4 different writ petitions. Paragraph. The petitioners before law on a single judge were the generating companies. What they called in question in the writ petitions was the state government's order dated 16/10/23, passed in exercise of powers under section 11 of the Electricity Act 2003. By the said order, directed all the generators of the electricity in the state to operate and maintain the generating stations at maximum exportable capacity and to supply the electricity generated to the state grid subject to certain conditions. One of the conditions stipulated was that the ESCOMS, that is electricity distribution companies, shall pay to the generating companies at rupees 4.86 per unit provisionally, subject to the proceedings before the Karnataka Electricity Regulatory Commission under section 11 into 2 of the Electricity Act. The said order dated 16/10/24 came to be notified by the State Load Dispatch Center on 20th/10/23. It is recorded in the order dated 16/10/23 oblique 20th/10/23 that powers under section 11 required to be exercised as a matter of policy and in public interest in order to mitigate the
Oh,
severe power crunch in the state. Full stop. Taking into account the said consideration, comma, said aspect, comma, it was stated that the government of Karnataka directed all the generators in the state to run their plants to full capacity and inject all the energy generated to the state grid for the purpose of utilization of the energy within the state in order to bridge the demand and supply gap of the electricity. On a single judge set aside the said order and allowed the petitions. The main the reason which weighed with the with learned single judge in setting aside the said order dated 16/20/10/23 was that the directions that the powers under section 11 of the Electricity Act 2003 would not have been exercised by the state government in light of the decision of the Supreme Court. Energy Watchdog versus Central Electricity Regulatory Commission and others, 2017, volume 14, SCC 80. Full stop. Paragraph assailing the view taken by learned single judge. It was submitted by learned senior advocate Mr. Naganand, assisted by learned advocate. It was submitted by learned advocate general Mr. Sashish Kiran Sethi, assisted by learned advocate so and so, and learned senior advocate Mr. Naganand, assisted by learned advocate so and so, appearing for the respective appellants, that the observations in paragraph 24 of the judgment in Energy Watchdog Supra, which are sought to be placed into service by the original petitioners, have entire different context of facts. It was submitted that not only that, comma, before the Supreme Court, the scope and ambit of section 11 of the Act was not under consideration. Full stop. Learned senior counsels further relied on decision of the division bench of this court in GMR Energy Limited through its director versus Government of Karnataka into bracket ILR 2010, Karnataka 2620, which submitted learned Advocate General as well as senior advocate, that which submitted so and so addressed the very issue of exercise of powers by the state government under section 11. It was held therein. It was held by this court. It has been held by this court in this decision that the state government has been vested with the power under section 11 of the Act to issue directions to a generating company to operate and maintain state government has been vested with the power to issue direction to a generating company to operate and maintain any generating station in accordance with directions of the government. It was stated, it was observed that the power so vested has to be exercised only in extraordinary circumstances. Paragraph. It was further pointed out that in GMR Energy Limited, the division bench, while holding as above, was dealing with a similar situation and observed that when there is scarcity of electricity and such generating company is not producing electricity, the power could be excised. Looking to the rival basis. It was further undisputedly pointed out that the decision in GMR Energy Limited, Supra, was carried in SLP before the Supreme Court, and the Supreme Court has not reversed the same.
Withdrawn as become infructuous. It was withdrawn as having become infructuous.
Honored advocate for the respondents' original petition submitted that the SLP was withdrawn. Full stop. In response to the same, it was submitted that nonetheless, the decision in GMR Energy Limited, Supra, holds the field. And that learned single judge could not have disregarded the same. Paragraph. Having regard to the rival contentions based on the decision of the Supreme Court in Energy Watchdog, Supra, which was sought to be distinguished by learned counsel for the appellant, as well the decision of the division bench of this court in GMR Energy Limited Supra, the appeal deserves final consideration since issues are to be threshed out at length, will have to be threshed out at length. Paragraph. Therefore, the appeal is admitted. The same shall be listed for final hearing. When shall we list? 19th of June? 19th of June. Paragraph. Learned advocates for the appellants, pressed for the interim relief. There is no gainsaying that the issue involved and the repercussion which may arise by virtue of the judgment and order of learned single judge, setting aside the order of the government passed under section 11, has a public interest dimension. Full stop. The purpose with which the state authorities are guided to exercise the powers under section 11 of the Act and to pass the order dated 16/20/10/24 is to ensure that, ensure that the scarcity of power in the state is overcome by bridging the demand-supply gap. It was submitted, it could be submitted that therefore it was to be in public interest that the power generation by the electricity generating companies, like the petitioners, like the original petitioners, congregate in the state rate only, so that it could be utilized in the interest of the state. It was further submitted that the utilization of power is in many areas, including for essentials of life of the people at large. Having regard to the aforesaid aspects involved in the aspects and the aspects, the court is inclined to grant interim relief. Full stop. Judgment and order of law in a single judge shall remain suspended till the next date. (23) 16/2020.
23.
In the middle, section 11 reads as under. Put it at appropriate.
But in my appeal, there's one office objection which we have replied, my lord. They say one copy is not clear. We have filed a clear copy, but the office, my lord, says something. Annexure J, my lord, that office objection may kindly be overruled. I produced a clear copy.
You have produced it?
Yes, my lord.
Once you entered in the
Disposal.
but this will finish it so that
No, every state will now, my lord, invoke section 11 and scuttle the central.
he says that observations in paragraph 24 of this judgment will analogically apply even to the exercise of power of the land.
Yes,
Will
that is, my
In fact, my
lord,
lord,
the
the
whole issue.
law as laid down as long ago, my lord, in the 50s by the Ozo Lords, is that the decision is a precedent for what it decides, not what logically follows.
In fact,
All those
Padma Sundaram and others, my
But,
lord, they said that in one fact situation, if a law is laid down,
Pin versus Lidham, Lord
Lidham.
Salisbury's judgment,
Lord.
2001.
just
minor difference in fact will
make a,
fact, Lord, Central Commission has issued advisory saying such issue should not be dealt with.
will see.
And there is no cabinet approval also for the decision. Anyways, I read that. Cabinet approval. like,
that is part of the appeal memo, my lord.
Just give page number.
Page number, just
in- It was annexure K. Yeah, SLP. Yes, annexure K, my lord.
Annexure K in the first,
Yes.
in your appeal,
In the-
state appeal. All right, not necessary.
Also to be kept in chamber.
Yes.
Common.
Then not necessary to be for-
Grateful.
I'm sorry, my lord, we have detained your lordships, my lord, beyond court hours. Apologies. We had to trouble your lordships not on board them. my lord.
This is for pronouncement of judgment, writ appeal 381 of 2024.
So in view of the foregoing discussion and reasons supplied by this court, in addition to what is recorded by learned single judge, judgment and order of learned single judge dismissing the petitions books no error and deserves to be upheld. The present writ appeal is liable to be dismissed and the same is accordingly dismissed.
My lords, if I may be permitted, my lords, the leave of the court. If the order may be stayed, my lords, for a period of 10 days, my lords. My lords, I'll- My lords, the
What can be
prayer,
stayed?
my lords, the reason being,
But what can be? Applying the principles of CPC, my lord, what can be stayed is only execution of an order. When a petition is dismissed, there is nothing to be executed. Therefore, the question of stay doesn't arise.
my lords,
No, but he is.
No, that's a view taken by this court. For order 41 rule 5. The petition was dismissed.
my lords, if I may be,
It is 90 days. without-
Only execution, my lord, can be stayed.
They are saying that it was in operation.
Well, no, but can you see, well, that's
My
all
lord.
right, but stay may be in operation, but it does, but if the petition is dismissed, the interim order does not automatically come to the rescue.
Which
No.
is that article?
It goes,
Give that article.
in fact, there is a judgment of this court, my lord, takes this view. Order 41 rule 5.
At this stage, learned advocate, Mr.
Sharan Kukreja, my lords.
So and so,
Sharan
so and
Kukreja.
so. For the appellant
Appellants.
requested. After pronouncement of judgment, after pronouncement of judgment, learned advocate, Mr. So and so for the appellant requested to stay the present judgment,
My lords, and extend the interim protection.
enable the appellant to avail, to approach the higher forum. Full stop.
PC or 41 rule 5 2, my lord.
In view of, in the facts and circumstances case, and in view of what is held by the court, it is not possible to accede to the request of the appellant. Accordingly, the request is rejected.
Like,